Hi, I'm Natalie Keller, and in this portion of Minors Counsel, we will be going over relevant case law and judicial counsel forms that hopefully will be of assistance to you in your practice as Minors Counsel. I would just advise you to review these cases in detail because we're just going over those briefly today. And so with regard to relevant cases, there is the case of In re David C., 1984, 152 Cal App 3D. And in that case, it was determined while counsel for a child must consider the child's preferences, they need not follow them when they are not in the child's best interest. Also, another case is Carroll versus Superior Court, 2002, 101 Cal App 4th, 1423. And in that case, the court decided that an attorney may not continue to represent multiple minors among whom there's an actual conflict of interest. And when an actual conflict arises, an attorney must be relieved from representation of any of them. Additionally, we have the case In re Richard E., 1978, 21 Cal 3rd, 349. And in that case, when a child's interests are not protected by contesting parties, a court must appoint counsel for minors. In re Marriage of Metzger, 2014, that's 224 Cal App 4, the Court of Appeal in California determined that the appointment of minors counsel in a child custody and visitation case does not violate the constitutional right of a parent to determine what is in the best interest of their minor child. Additionally, there is a fairly new case in the matter of A.F. versus Jeffrey F., and that is 79 Cal App 5th, 737. And in that case specifically, the court had distinguished the difference between minors counsel in a family law matter and minors counsel in a civil matter, specifically a domestic violence restraining order. And page 7 of 8 of the decision, section 13, the court stated further, the comparison is inapt. A neutral minors counsel in a dissolution plays an entirely different role than counsel hired in a civil matter. In family court, counsel for a minor has a statutorily imposed duty to present to the court recommendations based on what the attorney believes is in the best interest of the child, in addition to the child's wishes. In a civil matter, however, attorneys representing minors or any other party who has a guardian ad litem are bound by the Business and Professions Code, section 6068, and the State Bar Rules of Professional Conduct, and have an obligation to zealously represent their client's interest within the bounds of the law. And additionally, the court needed to consider, while father in this case may have preferred the allegations of AF raised in her domestic violence restraining order petition to have been raised in the custody context in a dissolution marriage, the Domestic Violence Prevention Act allows a child to file a petition as a party to the action. Additionally, it should be noted through the California State Bar, there is a formal opinion, 1976-37, that states an attorney representing a parent in a custody dispute may not recommend that attorney be appointed for a child without consent of a client. This is an opinion that was advisory only and did not bind the State Bar. Additionally, we will go over some judicial counsel forms that will be used in your practice as minors counsel. The first one that we would go over is the FL 322, and that is Declaration of Counsel for a Child regarding qualifications. On this form, minors counsel does declare that if they appeared in court and were sworn, they would testify to the truth of the facts in this declaration. Specifically, minors counsel would need to include the date that minors counsel was appointed to represent the minor child and list the name of the minor child. Specifically, license and insurance questions are addressed on this form. Number 3, that states, I am a licensed attorney and an active member in good standing of the State Bar of California. And number 4, I have professional liability insurance or am adequately self-insured as previously determined by the court. On this form, additionally, Minors Council will declare their education and training that was effective as of January 1st, 2009, and state that they have completed at least 12 hours of education and training in the subjects listed in California Rule of Court 5.242C. Additionally, Minors Council will need to disclose their experience, and as Section 6A states, I have complied with the experience requirements of Rule 5.242F, and 6B states I have complied with any local court rules that impose experience requirements in addition to those under Rule 5.242. Under experience number 7, it states I have complied with one of the following alternative experience requirements stated in Rule 5.242G. And you can select an option, either A, I am employed by a legal services organization, government agency, private law firm that has been approved by the presiding or supervising judge of the local family court as qualified to represent a child in family law proceedings, and I will be directly supervised by an attorney of the organization, agency, or private law firm who meets the experience requirements under Rule 5.242F. Additionally, under 7B, you can select I am working in consultation with an attorney approved by the presiding or supervising judge of the local family law court as qualified to represent a child in family law proceedings. Or 7C, I have demonstrated substantial equivalent experience, and you are to provide a summary of that equivalent experience below. On page 2, the form goes over annual continuing education that was effective as of January 1st, 2010. And section 8, you can disclose I've completed 8 hours of continuing education and training annually in the subject areas described in Rule 5.242C. And you will sign this under penalty of perjury of the state of California. Additionally, I'd like to note there is the notice at the bottom of page 2 that says, notice, attorneys appointed to represent a child must file a declaration with the clerk of the court indicating compliance with California Rule of Court 5.242 no later than 10 days after each appointment and before beginning work on the case. I like to point that out as that is a very quick turnaround, those 10 days after appointment. Additionally, there are the Judicial Council forms, the FL323 info, and that has to deal with an attorney for a child in a family law case information sheet. As Minors Counsel, oftentimes you will find that either one or both parents are self-represented. And this FL323 info sheet is very helpful to break down what the law is regarding Minors Counsel, what your obligations are, what your rights are, and in a way that is reasonably easy to understand. So I highly recommend providing the self-represented parent with a copy of the FL323 info sheet. And lastly is the order appointing counsel for a child. As a bench officer, you would need to complete the order appointing counsel for a child either during the hearing or right after the hearing. I tend to prefer to do it during the hearing so I can have input from either parents or counsel as to the reason for appointment to make sure it is as detailed as possible. And on page 1, you would need to make sure the bench officer includes that the proceeding was heard on a specific date, time, department, and by a certain bench officer, and who was present at that hearing. Under number 2, it additionally states the court finds it is in the best interest of the child to appoint counsel to represent the child under Family Code Section 3150A. You would need to make sure that the bench officer includes counsel appointed for the child's name, their address, phone number, and email is optional. Additionally, the child or children's name must be listed, their date of birth and address if appropriate. And section 4, the reason for appointment. I find that if you can really fine tune or narrowly tailor the reason why Minors Counsel has been appointed, it tends to make their job a whole lot easier with regard to how much investigation and documentation they need to provide to the court. Additionally, section 5, determination of fees and payments. Counsel for the child will be compensated as follows. Section 5A1 says specify amount or rate and terms. Number 2 says the court reserves jurisdiction to determine compensation payable to counsel for the child. Number 3 states the court reserves jurisdiction to modify the compensation payable to counsel for the child retroactively. And 5B, the court finds that the parties are able to pay the compensation and expenses for the child's counsel. The parties are ordered to pay counsel for the child as follows. And there's many scenarios under section 5B, 5C, and 5D with regard to compensation. Additionally, section 6 is very helpful, the additional orders of the court, and that is for all parties to make sure that they're complying with what their rights and obligations are with regard to the proceedings. And then on page 3, the duties of counsel for a child is very informative to remind all minors counsel as to what their duties are once they are appointed. And then also number 9, counsel for a child has the following rights, and then it is dated and signed by a judicial officer. I do feel that section 9, counsel for a child has the following rights, is very helpful, especially for schools, hospitals, law enforcement, just so everyone is on the same page as to what rights the court has vested in the role of minors counsel. I hope this has been very helpful to you, and good luck with all your service to the court.